Today I want to talk a little bit about what to expect at trial. Trial is one of the most anxiety-inducing things one can go through. That's why they call it a trial. It's not supposed to be easy. But if you're prepared and you know what to expect, at least you won't have to deal with the nerves of the unexpected. So the first thing that you should expect at trial is that your attorney has spent a lot of time with you, preparing you for your testimony, preparing you for your cross-examination, so you know where you want to go with the case and you know what the other attorney is going to want to do as well. So all right, it's the date of trial, you're raring to go, you're excited, nervous, but there's a lot of hurry up and wait in the beginning of a case. You get there and you're going to have a whole long process of picking a jury. And we have an idea of what trials should be like from watching them on TV, but in reality, the beginning of these cases moves very, very slowly. You've got this jury selection process where everybody tries to deselect or eliminate jurors who are going to be bad. It's hard to really get jurors that you feel are going to be good because the other attorney is also doing the same thing. So that takes several hours at least while you go through somebody's backgrounds and you find out their experiences, and maybe if you're lucky they have experiences similar to what you went through, and if you're even luckier they see the world the same way as you would. So that's that. But now we've got motions in limine. It's a fancy word, but it means that you try to have a lot of the really nasty, dirty, prejudicial is the legal word stuff eliminated before the jury ever hears it if you don't think it's relevant. I had a case recently where the allegation, which was the plaintiff, the person I represented, said that her doctor had sexually assaulted her. So guess what? There were many other women who said the same thing, and that's really relevant. Of course, the fact that this doctor had sexually assaulted, or other women had said he had sexually assaulted other women, would be great evidence. But unfortunately, the law in Illinois is very clear that you can't have prior bad acts be used to show that someone acted in a certain way in this particular instance. And much to our chagrin, but quite expectedly, the judge followed the law and said that all these other instances weren't admissible. That was a huge issue in the beginning of the case. And if we hadn't had motions in limine and the jury heard about these things during the trial and then the defense attorney objected, but it'd be impossible for the jurors to kind of put that out of their minds. Once they heard that, they would, even if the judge said, no, that's not admissible, you know that people would be sitting there talking about it. So motions in limine are important. We've talked about jury selection. Finally, the trial begins with opening statements. Opening statements, you tell everybody how the trial is going to come together. You give them a roadmap that they can follow. You can't be overly persuasive, or some judges, and the law really is you shouldn't try to be overtly persuasive at all. You should just really tell folks what's going to be coming so they can expect it and deal with it, process it as they hear it. All right, finally, now we're putting witnesses on the stand. We're doing cross-examination. This is where you will come into play. All of a sudden, you kind of relaxed a little bit during opening statements, and you're sort of getting used to this courtroom, fancy courtroom with the judge and the deputies and everybody coming in and filing out and paying deference. Well, now it's your time to shine. So going back to that preparation, hopefully you were properly prepared, hopefully you know what's coming, and hopefully you're able to get the points out and tell folks what happened to you and how it affected your life. All right, so now we've got all the witnesses, they've all testified. The next part of the case is the closing argument. That's the part of the case that's most often portrayed on TV, and that's the part of the case that's actually kind of like it is on TV. It's exciting. It's people are bringing in their best points. They spent all these days or weeks accumulating all this evidence, and now we get to show why it was important and piece everything together so you understand what it was that we were trying to tell to you and why our side should win. closing arguments are over, deep breath, sigh of relief, but now the jury deliberates. The judge tells the jurors the law, and they go in and deliberate, and then all of a sudden you find out that they've finished deliberating. You get out and your heart's pumping because you see them with a piece of paper in their hand, and you don't know if they found in your favor or the other person's favor, and the judge asked the foreperson to tell the verdict, and I'll tell you what, your heart's pounding at that point in time. And then hopefully you get the news that you want. In order to get the news that you want, you really need to have an attorney who has prepared you, who is experienced, and is talented.
If you have questions or concerns, please contact Woodruff, Johnson, and Palermo at 630-585-2320 or toll free at 866-891-9211 for a free consultation.